Hi guys, soyez le bienvenu, bienvenue sur ma chaîne. Je suis Mujala Lua, and thank you so much for coming here once again. On this channel, I talk about law in Nigeria and law practice, infusing my own law practice experience into the conversations as we go on. So today, I want to talk about not sharing your winning strategy with the opposing counsel, not letting the cat out of the bag, not oversharing as much as you would like to be friendly, and as much as I encourage camaraderie at the bar, today let's talk about another aspect, doing what's best for you and your client and your case by not letting out your winning strategy. So I'm going to share two of my experiences for cases that are already done and dusted. You know that as litigation lawyers, as a lawyer in Nigeria, you know that you cannot comment on matters that are ongoing in court because they are sub judice, and I cannot even talk about matters that are ongoing because now what if the opposing counsel is watching and they already have an angle of what I intend to do in the case. So these are matters that are already concluded, and I want to talk about what I did and how I think that it can help you to. I'd love for you to always continue the conversation in the comment section, especially if this speaks to you as a litigation lawyer. Laymen will also learn something, and so will law students. So today let's talk about not oversharing and not letting out your winning strategy while maintaining camaraderie at the bar. So the first case that I want to share, I want to talk about, was an attempted murder case. I remember it clearly. When I got the file, I've told you before that I work at an establishment where, I'm under authority. So if they need it, if we get a file in our office, we have a superior that would decide what to do or who will go to court and what they would do. So we are not really, at liberty to do so much, by personal decision, so to speak. Not that we are robots anyways. So it was an attempted murder matter. When I got the file, I read it up, even though the court date was about a month away or even more thereabouts. So what happened was that according to the legal advice that I read, it was a motor park situation, and some guys had gone to greet the head of the park. They were hailing him, and the process of hailing him, someone fired a shot and missed them, like a hailing shot, doom doom, something like that. That's the story that was in the legal advice. And then the shot now hits the very park manager, hit him in the leg, and so the person that fired the shot was caught, was reported, and then was charged for attempted murder. So the office of the DPP decided to charge the person with attempted murder. So I was supposed to go to court for that file alongside my colleague, of course. So when we got to court, so before that time, I'd called the witnesses in the matter, and they had assured me that they would be in court. I'd read up the file. There was no pending bail application that I could have, replied by filing a counter affidavit. So on the court date, when I got to court, I called, I liaised with my witnesses. They came out. I spoke to them. The lawyer was there, and so we would likely go on because the case was for mention that day. Although I've said it on this channel that for criminal matters, even if it's for mention, if the court is ready and both parties are ready, the matter can go on after it's been mentioned the same day. So I spoke with the lawyer, and he was he intended to go on, but he had a different strategy which he shared with me, which I'm going to share with you. The lawyer told me actually that actually it was a misunderstanding. They do not intend to that we don't have to go to trial. That the witnesses that I had called, apparently they were also his clients, so they were like one big family. So it was a case of a cousin being amongst those that went to hail the park manager, who was his uncle, and then he had fired the shot. And because there was a shot, his own father actually took him to the police station to report him, and then that was why the file was forwarded to the office of the DPP, and what happened, and then we found ourselves in court. So that the family had resolved that it was a family matter. They were settling it amicably. They weren't going to trial, and they wanted to settle out of court. I said okay. When the lawyer told me that they were not interested, I asked him that why didn't you file a bail application since all these days? It's been about 2 months or thereabouts since the matter happened. So I asked the lawyer, if this was the case, why did you not, one, Why did you not file a bail application? Why did you allow this young man to remain in custody? If it was already a family matter and all of that. He said, actually, he came to court because he expected that we would come and withdraw. I said, withdraw? Did you come to our office? Did you speak to my superior about withdrawing the matter? You know that I cannot withdraw a matter, even in the Administration of Criminal Justice Act. Under the proper laws of Nigeria, only the Attorney General can withdraw a matter, except if he delegates an officer in his chambers to actually do that. But the law only gives the Attorney General the power of nulli prosecute. I think we should talk about nulli prosecute also on this channel. I would try to remember and do a video on that. So nulli prosecute means that if the state has filed a matter, they can come back and say that we are not prosecuting. But that power only lies in the hands of the Attorney General. You know this. So I asked him that, have you come to our office? He told me that actually they have a sworn affidavit to the effect that they weren't going to trial, and then he showed it to me, and then he had taken it to the office of the Attorney General. I asked him, where's what you filed? He showed it to me, and it turned out that it was filed at the magistrate court. Their intention to withdraw, you know. And then I told him, I said, how can you file an intention to withdraw headed in the heading of the magistrate court when you know that this matter is at the High Court? Will you present this to the court? Will the High Court, will a High Court judge take a process that is headed in the magistrate court, you know, from you? You know that this thing is coming up today. Why didn't you do your homework? You have two options: file a bail application or file an intention not to go to trial, and liaise with the office of the Attorney General and the Director of Public Prosecutions and let them give the order or come to court themselves to withdraw this matter. I told him, I said, I can't withdraw the matter. So I went outside, I called my boss, I told her that ma, this and this what's going on, and she told me, she said, okay, if that's what he wants to do, okay, take an adjournment, advise him to, you know, go to the office of the Attorney General and the DPP and file the proper application headed in the proper courts. So take an adjournment to buy him that time. Or two, put your witness, that is the nominal complainant now for starters, in the box and let them witness themselves to the court that they are not interested in pursuing the matter, that it's a family matter, all those things that their lawyer is claiming, which they were also claiming alongside the lawyer when I called them outside to speak to them in court. So I said, okay, man. So when I got in, so I told the man, I said, okay, let me take an adjournment so that you can file the proper application for withdrawal, and so that you can go to the proper offices and liaise with them. So the man maybe looked at me and thought, oh, she's a junior lawyer, she'll do my dirty work for me. He was saying that, no, you just tell the court that you are not interested in pursuing the matter. Tell the court that you are not doing the matter. I said, I can't tell the court that. You are their lawyer, I'm not their lawyer. I can't speak for them. You speak for them. Let me take an adjournment. Then he said, no, don't take an adjournment, because I didn't want to put the witness in the box. I didn't want him to go in the box and spoil his own matter. Because now what we wanted him to say was that he's not interested because it's a family matter. The boy that shot him is his cousin and they had settled it amicably. Now, the lawyer was insisting that, I said, I want to take an adjournment to buy time for you. You're saying that, no, don't take an adjournment, don't take an adjournment. So I said, okay, the court was sitting. So I said, so it was time for the court to sit. I said, okay, let's go in. So we went in. So apparently he thought that I had agreed that I was going to tell the court that we are not doing the matter. Why would I ever tell the court that? Please, I have my own career to protect, just as you are protecting your own interests. So when we got in and it was time for the case was called. Then I stood up, I announced my parents, and then I told the court that, okay, so this is what the matter is. My witnesses are in court, and the matter is coming up for the first time. So the court asked me if I was ready, what I intended to do in the matter. I told the court, I said, my lord, I'm ready to go to trial. But today I don't have the IPO. I have the civilian witnesses, and I intend to start with the IPO. That's a smart thing, because I cannot tell the court that I'm not doing the matter. If the court asks me why, I will now say that because parties have settled amicably. The court will now say that, is there anything before him showing that they have settled and they are not interested in the matter? I will now start looking like a dumb lawyer. No, God forbid. And then I couldn't tell the court that parties have informed me that they don't want to go to trial. It will look as if they bought me, they paid me. Let their lawyer be the one to say that for them. And honestly, I don't know why the man did not file a bail application. I said, why didn't you file a bail application? He said, oh, because he thought that I would come and withdraw today. You knew that the matter was for today. Not once did you call me. You came to you went to the office of the DPP. You went to the office of the Attorney General. Not once did you call me or get in touch with me. You saw our name. You know that we are the officers handling this matter, and yet you could not come and liaise with us ahead of time. So you want us to just come to court and do your bidding or what? And another thing that I try to do, which helps a lot and which would help any junior or young lawyer now, let me stop saying junior, any young lawyer now, is that when you get to court and you see that you're up against seniors, don't let them treat you anyhow. The thing that should be at the back of your mind is, how would they treat my senior? That's if you have a senior, if you're not in your own practice, When I was in my own practice, I held my own. But now that I'm under authority, I think to myself, what would they do if my senior were here? So anything that they cannot do to my senior in my own assumption or understanding, I don't take it from them. I do not. It's very important. Don't let, Bible even says that do not let anyone despise your youth. So as a young lawyer, don't let anyone play you. These people are for their interest. It's best to protect your own interest as well. So when I told the court that I intend to prosecute, but I intend to start with the IPO, I thought that I was doing him a big favor. One, I had not done his bidding, and two, I had still gone ahead to buy him time to regularize his position before the court, because the court will not take that application headed in the magistrate court, whether he tendered it or whether I tendered it, as proof that parties want to settle. So he got up. He jumped up. When you think you're doing people a favor, I don't know why they behave like this. He jumped up and was like, "Milord, I don't understand the I think he said sudden turnaround of the council. We have discussed outside. Gosh, why would you say that?" So now imagine that I had done what he asked me to do. Would he have also gone up and told the court that we have discussed? This thing had happened to me at some point. There was a time that there was a matter I was to go for, and there was some K-leg with the matter. So I prevailed on my senior that let me call the other lawyer on the other side, because I really believed, and I still believe in camaraderie at the bar. Let me call the lawyer on the other side, explain this situation to him, so that when we get to court, we will not waste the time of the court and our time, and we'll be able to get something done. So I called him. He came to our office. My senior discussed with him. So we agreed on what was going to be done. Do you know that when we got to court the next day, he was referencing the fact that he had been in our office, which looks compromising. We had called you not to compromise the situation, fair enough, but to actually set things straight, so that we will agree on a strategy, and when we get to court, things will move fast. And then you come to court and you are telling the court that you were at our office and we discussed what? So I knew that I had to keep these people at arm's length, so that they will not cobalize me, as you say in Nigeria. So he got up and was telling the court that he doesn't understand my I always call it apostolic turnaround when I tell people, but now that I'm thinking of it, I think he actually said sudden turnaround, or whether it's apostolic turnaround. I just said, "Beloved, I don't understand the sudden or the apostolic turnaround of the learned council. We have discussed outside. We have done this and that." And he was a very imposing man. He was tall, huge, and had this strong, commanding voice or tone. So Milord now looked at me that, what do I want to do? I said, "Milord, I intend to go to trial, but I want to call the IPO first. So I'm taking an adjournment to facilitate the presence of the IPO in court, even though today my civilian witnesses are here." So the court took judicial notice of the fact that I was ready. I brought my witnesses, but that I wanted, to take the IPO first, which is permissible anyways. And maybe the court also understood what I was trying to do, because the man now was telling the court stories that parties have settled, they are not interested in trial, and he has told me he has done this, he has done that. I was just smiling as where I was. So the court said that if parties are settling, where is his application? Where is the proof? Where is the document before the court showing that they have settled? Or does he intend to come and tell the court with word of mouth? Another reason why I did not take the second option my senior gave me, to put the witness in the box, is that once I put him in the box, I've opened the matter. essentially. And so the other party, his own lawyer, has to cross-examine him. So I was already looking at, that means that we have gone to trial, essentially. And what if the things they are saying is something that would provoke further trial instead of pegging it at one witness? So I said, let me buy time and let them do the proper thing. And so the man was furious, and well, that was what went down. I'll keep the rest of the detail because the matter is now concluded, and he went. he had a very interesting, different interesting twists and turns, but the matter is now concluded anyways. So that is one experience to show you that even if you discuss with the other party outside of court, do not let out all your strategy. Do not tell them the very last of what you can do, the options that are available to you. And even if you discuss a direction with them, if it would appear on further thought, or when you get into court, if it would appear as if or that that will prejudice you or shoot you in the leg, please take another direction, because they would not hesitate to take another direction if places were switched. So that's what happened in that case. I want to talk about another instance where I got emotion, and when I got emotion, I tried to trace the original file. I said that they send us files and tell us what to do. So when I got the motion, and I tried to trace the original file so that I could get a full hang of the full story. That's what I always do for my cases, way ahead. I think it was like a month ahead, also. So when I got it, I couldn't trace the original file. So I looked and looked and looked for it. I couldn't find the original file. So when I checked the motion, I found the lawyer's number that had filed it. Now that motion had a problem. The affidavit in support of the motion was filed for 2 people. And it's just basic that affidavits are personal. In Nigeria anyways, but I guess all around the world too, affidavits are personal. 2 people cannot swear one affidavit. It has to be 1 person, 1 affidavit. So if there are 10 people in a case, it has to be 1 person per affidavit. So 10 affidavits. This lawyer had filed, a very senior lawyer too, because when I saw his seal, and then I saw his because when I saw his seal, I could tell that he had been at the bar for so long. You can tell by someone's Supreme Court number, actually, if you're keen enough. So he filed an application with an affidavit with 2 names. The name of the 2 defendants were on the affidavit. So what I did was I called him. Why I called him was I couldn't find the original file, so I had to call him to get a full gist to appreciate the entire situation. But when I called him, I didn't tell him that he had filed affidavit with 2 names, because that's my option B. So in case he decides to go on. So I'll tell you about that much later or very soon. So when I called him and I asked him, I said, sir, I'm the counsel handling this application that you have filed, and I've tried to trace the original file. I could not find it, this and that, blah 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 blah. So he told me that that the thing is even that he has filed another application in another jurisdiction, because the accused persons have now been charged in another jurisdiction where they actually committed the offense. So I think he was saying something along the line of they having been caught in my jurisdiction, that's why he filed an application there, but that they actually committed the offense in another jurisdiction, something of the sort. So but essentially he said that he had filed the application elsewhere, that he was even planning to come to my jurisdiction to withdraw that application that I had. I say, okay, great. So what that call had saved me, so what that call has done now is that it has given me a full appreciation of the matter, and now I don't have to file a counter affidavit. I don't have to waste my efforts. Since I couldn't trace the original file, the person has told me that they want to withdraw, so no need for filing an affidavit. So you see, that's what camaraderie at the bar will do to you. It will do a lot of good. So I'm not encouraging that you should be enemies with your co-counsel or opposing counsel. I'm just saying that know thyself, and the stomach is very far. You don't know what people want to do. You don't know the plans they have for you. So it's better for you to plan your own too. So like that first one, like that one that I referenced, when the man came to court and was saying something else after we had already agreed on something. So what I, however, did not do is that I did not tell him that I noticed that he had filed an affidavit putting 2 names when affidavits are personal, because now I plan and assume that what if it comes back to court does not withdraw the application until the application day, and then moves the application, what will happen? What will be my defense, since I wasn't filing a counter affidavit based on his word, which is just word of mouth, and I had no documents to support the fact that, there was no case in our jurisdiction. So I kept that, and I waited so that if we now get to court and then he now decides to move the application, my counter, my opposition would be that the application is not competent because the affidavit in support was sworn in the name of two people. And even I think the Supreme Court or Court of Appeal has decided that applications, affidavits are personal in nature. So one person, one affidavit. So I kept that. So eventually on the court date, he didn't even come to court, and he had not withdrawn the application, as I found. So I told the court that I wanted to strike out the application for want of diligent prosecution, and the judge refused because he said the motion was coming before him for the first time, and that particular judge, he likes filing applications, so he will file it for them, keep it for them. The day they wake up, they'll come and move it. For instance, that other case that I referenced, that I called the man to our office and we discussed with my senior and all of that, the man actually filed the application. Let's say he filed the application in like January, and by March, that's 3 months ago. That's 3 months away. He came to court to move the application. What I suspect was that he had gone to another court to try to move the to file similar applications, which is abuse of court process really, and maybe it was denied. So he kept this one in our court. He kept it on file that, okay, in case I don't get what I'm looking for in other courts, I'll just come back and move the one here. And because probably he knew that our judge was the judge that would not delete or strike out your application, he will keep it for you until you wake up one day and decide that, okay, I want to come and move it. Can you imagine? So when I saw that he hadn't come to withdraw his application, I asked the court to strike it out. Court said we're coming for the first time, so he's going to keep it, let us come one more time before he can strike it out. So I now told the court that I've actually called the counsel, and he told me that he had filed elsewhere because the matter is no longer within this jurisdiction, and that's why I'm applying that it be struck off. So I didn't even have to use my plan B, but I had it. So the court now struck off the application. So that's another thing. Don't let applications just lie fallow in court. If they are not there to move it, and please strike it out if possible, because they can decide to wake up and come and move it, and it might be against you on that day when you think that the worst is past. I'm just speaking from my experience. Anyways, I'm not saying that you should go to court and try to be striking off every application that you run into as an opposing counsel. So that's what happened in those. So that's what happened in those two cases. I've done a video where I talked about how to have a BATNA and a WATNA as a young lawyer going to court. That's your worst case scenario and your best case scenario. And now I've talked in this video about how not to let out your winning strategy. Don't put all your cards on the table, with the opposing counsel, no matter how nice they are. Make sure there's something that you're hiding that you can still go and bring out and use, if push comes to shove. I just also recalled that there was a time that we were in one matter, and my senior, she likes talking to other counsel. I don't like it. I like keeping to myself in court, because I don't want to say something that you use against me. And I find it difficult when we have joked and laughed and been jovial with each other in court before the court sits, and when the court sits, you are being antagonistic and adversarial to me. I'll begin to wonder, is it not this person that I was just joking and laughing with? So to avoid that, I will kukuma keep to myself. I will greet you, I will smile if I can, or if a situation warrants it, but I will keep to myself as far as my case is concerned. Yeah, so because sometimes I sit beside seniors that want to talk at all costs, so I'm forced to actually talk to them, to respond to their conversations. Sometimes they are beautiful conversations, sometimes those things are not my cup of tea. So but you meet different people in court. So that day we had amended our process, and there was a mistake in the amendment, which meant that if my senior had gone on to ask the court to strike off our former process and substitute it with the amended process, the defendants would have gone home free men. that day, because that would mean that the fault in our new process would mean that we have no case against them. And this opposing counsel, they about 2 or 3, who had been smiling and laughing and joking with my senior all the time, knew this, and they did not call our attention to it, despite the fact that they were served, which is how they kept, their own winning strategy. So when the matter was, I think it was the court that discovered it on its own accord, and then my senior had to apologize and ask for a date to regularize our process. And then she even tried to go on and say the court should now put the new one on record. So but we now had to ask for a day to regularize our process. So when we're going on, those other opposing counsel were still joking with my senior. I think they were friends from way back out, and it was like a long case that had been on for about 2-3 years. So one of them now told my senior that they actually saw that fault. They were waiting for her to substitute so that they can tell the court that we no longer have a case against their clients, and so that their clients can just go free men on a platter. So you can see that they kept their winning strategy, even though they were shining teeth and smiling and cracking jokes with my seniors. So that's very important. No matter how friendly you are with the opposing counsel, don't put all your cards on the table. Very important. But I'm not saying subvert justice or waste time. So if it's something you have to disclose so that things can move fast and everybody can go home, that is in the best interest of everyone, please by all means disclose it. Or if it's something that is so grave that it can affect the other party adversely, or tamper with justice, by all means disclose it. That's not what I'm saying, because that would be unethical. What I'm saying is that your own winning strategy in a fair situation, don't let it out. Don't put all your cards on the table. That's all I have for you in this video. Let me know in the comment section if you have ever had to put all your cards on the table, and how it turned out, or if you had ever kept your strategy and how it turned out. Let's continue the conversation in the comment section. And don't forget, if you loved what you have watched, give it a thumbs up. Thank you so much. I'll see you in my very next video. Toodles.